Good afternoon, Advocate Swanepoel. How are you? Good.
Excuse me, I'm very well, thank you.
All right. Exactly a year ago, it was on this very day that you sat in that position, wherever the JSC was sitting on that occasion, and you were interviewed.
That's correct.
For a vacancy in the Gauteng division. And we have that, a record of those proceedings in our pack here. And it was quite thorough, as I recall. Now, I'm not going to take you back to your CV. We know about you. We've interviewed you publicly, so the South Africans know who you are. I'm just going to ask you to elaborate on two aspects mentioned in your application form. At page 9, at paragraph 6.1, you seek to elaborate on a matter, an aspect that you feel you did not address properly during those interviews, and I suspect you think it may have something to do with why you were not recommended, I don't know. So if you want to just talk to us about that.
Yes, thank you, Deputy Chief Justice. I was asked on the last occasion why I should not be appointed before a member of the, for instance, the Johannesburg Bar. And the question was that the members of the bar are at the coalface of the profession on a daily basis. I think I let myself down a little bit with that answer. What I didn't make clear, I believe, is that I have 35 years' experience as a prosecutor, as an attorney, and as counsel. On virtually every one of those, days that I was at work, I litigated. I litigated in a wild field of law. I've set out in my application the law that I've dealt with. So what I didn't make clear is that, in fact, I'm an experienced litigator. It's not a question that was when I was an attorney, for instance, that I sat in the office. I did the litigation myself. As counsel, I've done the litigation myself in a wide area of law. That I didn't make clear, I believe, Deputy Chief Justice. And perhaps you're right, perhaps that did have an effect on whether I was recommended or not.
So what have you done in the past 12 months that you think would have enhanced your resume,
well,
such as to impress the JSC to find in your favor this time around?
Thank you. That is a question which I was hoping to be asked. Deputy Chief Justice, I have an additional 13 weeks under my belt on the bench. And it takes my total to 86 weeks in total. Of those 13 weeks, I spent 4 weeks in the urgent court. In the 1 week, I was the senior judge. So from that point of view, I feel I've got a lot more experience. And I must say that what resonated with me yesterday it was Judge Wiener's remarks, that in this particular job, experience, I believe, is all. It's very important. So I have a lot more experience. The second thing that's happened is that I was very fortunate to be allocated a long trial, a medical legal trial during the course of last year, and I wrote a judgment in February, quite a complicated judgment which I wrote in a matter of 11 days, I believe it was. And since then, I have been allocated a number of medical legal matters, I think 2 long trials recently. So I've gained a lot of experience in those matters, and I think I can add value hearing those kind of matters. Mm-hmm. The third thing that's happened is as a result of this commission, quite ironically, I was rightfully criticized last year for the lack of depth of my knowledge of the Constitution. I have subsequently worked hard on it. I've read widely. I believe I understand the Constitution and I'm able to apply it properly in matters that come before me. That was the third thing. And the fourth thing was that, and this stemmed from a comment that I heard Commissioner Malema make in an interview with an SCA candidate in the previous interviews. And he asked the candidate, well, is a court intentionally intimidating, and what effect does that have on whether justice is seen to be done by people appearing there and people attending court? And that resonated with me. It made me realize that what one needs to do is to make sure that people feel comfortable in a court without affecting the dignity of a court. And to make sure that when people leave there, that they understand that they have been heard and that their case will be properly considered. So I've, specifically in the last few months, I've worked hard at creating that kind of an atmosphere in my court. So I believe I'm a better judge than I was on the last occasion. Those are really the four things I think that have changed in the last 12 months, Deputy Chief Justice.
But have you produced a judgment on a constitutional issue?
I have. I've produced two directly on the Constitution.
Two?
The one was relating to Section 3(1)A of the Agricultural Products Act, Standards Act, where I was asked to declare the section unconstitutional. I found in that matter that it was not inconsistent with the Constitution. It was not invalid. I was also asked in another matter to find that the education policy of the Correctional Services Department is unconstitutional. I did not find it was unconstitutional. Eventually, towards the end of the matter, the attack by the applicant was focused on and based on PAPUDA, Section 14 of PAPUDA, that it was discriminatory. I found that. I did not find that the act itself was invalid. I found that there was unfair discrimination towards an inmate. So yes, I've written those two. I've written a number of matters in respect of PAJA. So I have some experience in PAJA matters as well, Deputy Chief Justice, yes.
All right. Well, the professional bodies have sent us generally good comments on you, on your abilities. But Nadel has asked us to find out what involvement, if any, you've had in advancing transformation within the profession and also ensuring access to the profession. What did be your response to
Yes, thank you for that
concern?
For me to properly answer that question, I have to explain where my career took a little bit of a sharp turn, which I'm actually grateful for now. Towards 2008 and 2009, I was working with a lot of single practitioner, young upcoming attorneys, and some of them black attorneys, whose clients didn't always have the wherewithal to pay for counsel and to come to my...
I'm sorry, Advocate, for some reason I'm struggling to hear you. Can you perhaps
I'm sorry.
put your mic closer?
Is that better, Deputy Chief Justice? Is it better?
Marginally, but yeah, it's better.
Is that better?
Mm-hmm.
Thank you. My attorneys weren't representing people with financial means to a large extent. I was doing a lot of pro bono work and I was doing a lot of work at reduced rates. So it wasn't always feasible for clients to come to my chambers in Sandton, where I was at that stage. At the same time, I became very much involved in community work. I became involved with the New Beginnings Foundation. We worked with a homeless shelter with 1,500 people in it. We did their pro bono work, we worked with their youth, etc. At the same time, I was also running language classes for people who couldn't speak English with the view to try and get them into the economy.
Oh, no, we are well aware of your involvement with the community
sorry.
projects that seek to assist vulnerable members of our society.
Yes.
We're fully aware of those. We're asking about your efforts within the profession.
Yes.
Yeah.
Sorry, Deputy Chief Justice, I'm sorry if I was long-winded. What I wanted to say was my career path wasn't one of being at the bar where I could bring in junior members of the bar. It was never that kind of a practice. So I wasn't able to do that. But what I have done is, over the years, I've mentored a lot of the young attorneys who have briefed me. I've mentored their article clerks. My door has always been open to them for advice. One of my attorneys particularly has appointed black women as article clerks, and I've mentored those people. Recently, my last stint, one of them was in my chambers when I was doing urgent court, and my practice is to take the papers, explain to them, take them to court, and afterwards debrief. So I've tried to add value in that regard, Deputy Chief Justice. My career path was really not one where I was ever in a position to, my clients couldn't afford 2 counsel, sometimes not even 1. So it wasn't the kind of career where I could say I want to uplift, for instance, black women, or and advance them in that fashion.
All right.
I'm talking about counsel now.
Yes. All right. Thank you. Do you have questions for the candidate colleagues? Oh, JP Mlambo.
Thank you very much, Deputy Chief Justice. Good afternoon, Advocate Swanepoel.
Good afternoon, JP.
I'm not going to go deep because I asked you a lot of questions about your spreadsheet last year, which speaks for itself. I mean, it's now a total of 86 weeks
Yes.
you've given to the division. And I think, like Advocate Holland Muter, you've told us that should we find ourselves in a predicament, we can call on you and you'd be able to come and assist. Am I correct?
That is so, JP.
And in fact, that's what you've done throughout your acting stints.
Yes, I have, JP, except when I've had other matters when I really couldn't assist, I would have tried always.
I mean, what's remarkable about you, of all the Gauteng candidates, is the spreadsheet suggests 11 weeks in the urgent court. I think there are statistics missing if it is indeed 11 weeks. But I've counted 6 weeks, that is 2 weeks each. In 2021 and 2022. But you can correct that. Have you done 11 weeks? I actually get a sense you've done a lot more than 6 weeks in the urgent court.
JP, this isn't accurate.
Yes.
What happened from time to time is I would, for instance, finish my opposed role by Wednesday, and then I would spend more time in the urgent court. I'd make myself available in that court. I spent an entire week, I think, in 2020, the week before the lockdown. I spent in the urgent court because the second urgent judge had gone into isolation. So I took over with Judge Mayer, and we ran the 2 urgent courts just before the lockdown. So that has happened much more often. I have spent more time in the urgent court than is actually reflected here.
Yeah. And you've done 3 weeks in the special motions, as well as 11 weeks in opposed motions.
Yes, that is correct, JP.
Right. Have you ever reserved any judgment longer than 3 months?
I believe there were 2, JP. The one was a matter in which arose from my unopposed motion court. I saw that the matter was ripe for hearing. The parties said they would hear it, and I heard it in the afternoon of my unopposed motion court.
Yes.
But then, to give the parties an opportunity to put their case, finally I invited them to do heads of argument, which only came to my attention on the 90th day after the matter had been heard. And when I got the heads of argument, I wrote the judgment in 2 days. The other one was an extremely complex matter. Amendments had to be brought in a 750 million rand claim. It took me a while to get all of those. The papers ran into something like 150 pages, just the plea and the particulars of claim. And I had to be very particular about reading the papers. So that took me about 3.5 months.
Yes.
But other than that, other 116 judgments, I think I've delivered in 11.17 days.
Yeah. I think you've addressed some of the issues that arose in your previous interview that DCJ raised.
Yes.
The fact that you left the conventional bar but you continue to practice, are you in good standing with the LPC?
Yes, I am, JP. I've been a member of either the bar, the LPC, or the Law Society for 27 years. There's never been a complaint against me, and I am a member in good standing. I always have been.
Yeah. And you've told this commission that since your last interview, you've written 2 constitutionally involved cases, and you've dealt with a number of PAJA cases.
Yes.
Right.
JP, in fact, that was before the last interview. I'd already written those, yes.
Okay. And I've seen in your spreadsheet that you've done a number of full-term stints, so you know what it's like to carry a full judge's load in Gauteng.
Yes, I do, JP.
I see. And you regard yourself as ready?
I do believe I'm ready. It's something that I've grown into, and I've become comfortable with, and I believe that I can handle the work.
I see. Thank you very much, DCJ. No further questions.
No, I'm okay, thanks.
Thank you very much, DCJ. Good afternoon, Judge.
Good afternoon, Commissioner Maramoache.
You wrote one of the most, I operate in the pension law space, right? You wrote one of the most useful judgments in pension law. I'm not sure if you still remember it, Swart versus Lukaimani.
Yes, I do remember it on
Section 36,
Section
37 of the Pension Funds Act.
I do recall it,
7C
yes.
of the Pension Funds Act. I just want to pick your brain because I agree with everything in that. Judge. I think it's one of the, and I'm happy that you marked it reportable. What do you think should be done in relation to the way in which retirement funds distribute death benefits and the way they exercise their discretion? Because we are yet to find solutions in relation to this provision, Section 37C of the Pension Funds Act. Yes. We currently had a decision, Collards versus Collards, that came out, but we do not have absolute clarity as to how this section should actually be dealt with. What is your view on that section?
What struck me in that matter is the arbitrary manner in which the pension fund had gone about deciding on the distribution. And even when it was pointed out to them that the facts that they were basing the decision on were wrong, they still nevertheless stuck to their decision. So I think that it might be good to give guidelines to the pension funds. Perhaps the legislation should be more particular about what factors should be taken into consideration when a pension fund does distribute funds. But at the moment, it seems to me to be a completely arbitrary process without any guidelines that would cover the entire industry. So it seems to me to be from one pension fund to the next to be different, which is not acceptable.
Thank you very much. Thank you very much, DCJ.
Anyone else here? Commissioner Steinberg.
Good afternoon.
Good afternoon, Commissioner.
You were asked last time about the question of self-review. When a public entity reviews itself,
Yes.
what would you answer this time about how the public entity should approach that?
Are you referring to the Gajima judgment specifically?
No, just generally.
Well, I would imagine if I thought about that answer that I gave, and I said that they should walk away from it. Once an administrative action has been taken, I realize you can't just walk away from it. So something has to be done about it. And in which case, in Gajima, the Concord has said that you can't review by way of PAJA, you're going to have to review by way of legality. So once you've made an administrative decision, you can't walk away from it. You have to take action to have it set aside. That's how I understand it. I think my answer last year was completely incorrect.
You were also asked about Section 172.
Yes.
And discretion. How would you answer that now?
Well, Section 172, if one makes a finding of invalidity, that a provision is inconsistent with the Constitution, you have to set it aside. You have to declare it invalid. Then one can make any order that is just and equitable, which includes limiting the retrospectivity or suspending the declaration. So I recently read the judgment of Blind SA that the Con Court handed down, which to me gave me an extremely wonderful idea of how it should be, how 172 should be applied. There was a finding of invalidity in respect of the Copyright Act. And Justice Unterhalter wrote a judgment there in which he very finely and with a rapier, in a rapier-like manner, wrote into the Act, Section 13A. So that's how it seems to me one should approach it. If there is a finding of invalidity, then one must be very careful about not encroaching on the legislature, but you must then try and find a solution that's just and equitable, and even if it's in the interim, as it was in Blind SA, to find a solution to that invalidity in the provision.
And if, for example, you have a matter concerning a tender before you,
Yes,
and you find that the tender was unlawfully awarded,
yes.
what are your discretionary powers in that situation?
Well, like in the all-pay case, the tender was set aside, but because of the implications to the general public, the tender was left in place until another service provider could be found. That's one of the alternatives. If it is feasible, one just sets aside the tender, but one has to look at all of the surrounding circumstances, the implications for the general public, the implications for the service provider and for the state. So all of those considerations would come into play, I would imagine.
And then your options are what? What would your order look like?
Well, I would make an order that the tender is set aside. If I was to keep it in place like in all pay, I would say that the declaration I would say is suspended until a new service provider can be appointed. I can't recall what the all pay order looked like. But I would imagine that's how it would, at very basic look.
No, in fact, in a case like that, the order is that you declare the tender, the award, unlawful, but you don't set it aside.
Well, if it's invalid by way of because of the legality. Then I would imagine you would have to set it aside, but keep it in place. I can't tell you, Commissioner. That's as far as I can take it. I neglected to read the order in all pay. I should have.
Could I please follow up, Deputy Chief Justice? Because, you know, Mr. Swanepoel, Advocate Swanepoel, the problem is that administrative law is the heartland of litigation in
Yes.
Pretoria and in Johannesburg.
Yes.
So that's why I'm going to ask you these questions. What was the jurisprudential basis for the finding of the Constitutional Court in the Gijima case that legality is the gateway to judicial review in self-review cases?
Yes. Thank you, Commissioner. In that matter, CETA and Gijima entered into a settlement agreement, which it was common cause was contrary to procurement policies. So about 22 months after the agreement was entered into, CETA went to court and asked for an order in terms of PAJA for the reviewing and setting aside of that agreement. Now, PAJA was enacted in terms of Section 33 of the Constitution, which required the state to enact legislation in order to deal with administrative affairs. The High Court and the SCA held that, in fact, PAJA was applicable, that this was administrative action. In the High Court, I believe they found that because of that, in the 180-day period having been exceeded and no application for condemnation having been made, that CETA was out. The Concord went into quite a detailed analysis of the reason why Section 33 was in the Constitution, and it held that Section 33 was only available to persons. It wasn't available to the state. You can't have the state complaining against its own conduct. But it said that was not the end of the case. The conduct could still be reviewed under the principle of legality. And there it found that because the proper procedures had not been applied, the conduct was not lawful, and therefore it was set aside.
Yes.
There also, the result was that although that was set aside, Kojima wasn't divested of the advantages that it got out of the settlement agreement.
All right. I asked you about the jurisprudential basis, not a narration of the facts. The jurisprudential basis was that Section 33 confers rights on natural persons.
Yes.
And not on?
Not on the state, yes.
Yes. Now, the second thing I want to ask you is the discretion that Section 172 of the Constitution gives to a judge when they have found the award of a tender to be invalid. I don't want the case, you've discussed that with Commissioner Steinberg. I want the principles of law that flow from Section 172 of the Constitution.
Well, the first principle is if there is a finding of invalidity, you're obliged to set aside the provision or the...
No, Mr. Swanepoel, that's actually incorrect. You're not obliged to set aside. You're obliged to declare the act invalid.
Yes, excuse me, yes.
Let's go to the next one.
Yes, of course. So you're obliged to declare the conduct or the law inconsistent with the Constitution and thus invalid. What you can do then is you can read down into the provision and try or read into the provision and try and find a way to cure that inconsistency. Or one can sever certain words from the provision and make it consistent with the Constitution.
No, Mr. Swanepoel, that's also incorrect. That applies to a declaration of invalidity of an act of parliament, not
Yes.
to a decision of a tender.
Excuse me, sorry.
I'm talking about a tender. Give me the second step.
The second step in respect of the tender, well, then one would, if you set aside the tender, then one would try and find a solution in the sense that you would try and create a situation where the effects of the setting aside of the tender are alleviated as much as possible. So one could, like in all pay, hold that the contract still stands until another service provider has been found.
All right. That's also incorrect. What happens is that the judge exercises what is called a just and equitable
Yes.
jurisdiction,
Yes.
in which he can suspend the effects of the invalidity.
Yes. I believe I said that before with respect, Commissioner. I said that it can make any order that's just and equitable, including suspending the invalidity. Yes.
Now, under what circumstances could the invalidity be suspended?
Well, Commissioner, it would be suspended if the circumstances are such that one cannot simply terminate that service. For instance, and again I raise all pay, if there are thousands of people, hundreds of thousands of people relying on that service, then the only thing one can do is to suspend the invalidity.
So thank you, Mr. Swanepoel. The reason I'm asking you this, I gave you the preamble, that the heartland of Johannesburg and Pretoria is administrative law. And my problem, I need to put this to you now, is that your grasp of the principles is very shaky for me.
Commissioner, may I answer that?
Yes, it's indeed intended to solicit a response.
Thank you. Commissioner, there is not a single judge in this division who knows everything about every facet of the law. But what we are is we are able to research. With respect, you've heard about my judgment in Lukaimane versus Swart, where Commissioner Marmoache said that he thought my judgment was correct. Before I wrote that judgment, I didn't know much about pension law, but I was able to go and research it, and I was able to find the solution, and the correct solution. So I've worked very hard, Commissioner, at improving my knowledge of the Constitution, and I intend to continue to do so, because I believe we're all scholars in this job. We never stop learning. So I've never shied away from the fact that I am not a constitutional scholar, but I'm able to apply the Constitution, and I'm able to research and find the solution and write a good judgment on it.
Thank you, TCJ. I've got nothing else.
Thank you very much. Just, I have only one question. Good afternoon, Advocate Swanepoel.
Good afternoon, Commissioner.
Yes, no, thank you so much. I'm looking at at the questionnaire. You obtained your BA law in 1992 and the LLB in 1994, correct?
Yes, that is correct, Commissioner.
And you were appointed as a state prosecutor in January 1987, is that correct?
That is correct.
And between 1984 and 1987, you are not telling us what your occupation was.
I didn't have an occupation. I was doing National Service, Commissioner. So I did 2 years National Service as a law officer in 1985 and 1986.
Why you did not think it necessary to reflect that so that we don't have to ask it?
Commissioner, I didn't think it was relevant to my professional knowledge, but I don't shy away from it. And if you want my reaction to that period now, I would gladly tell you how I feel about it now, if I may.
No, it's fine. You were then, in 1988, you were appointed Attorney General.
I went to the Attorney General's office in the middle of 1988.
And you resigned that post 6 months thereafter?
Yes, that is correct, Commissioner.
Is there any reason why you resigned the post? Resigned from the post?
Commissioner, I had very quickly gone from being a district court prosecutor to being in the office of the Attorney General. But it had always been my dream to go to the bar. By the time I was at the Attorney General's office, I realized that prosecution wasn't for me. It was something which I enjoyed, I gained a lot of experience in, but I wanted to be in the private sector. So instead of prolonging my career at the Attorney General's office, I resigned 6 months later and I joined the bar.
Thank you very much, Advocate. Thanks, TCJ.
TCJ, may I do a follow-up on that, please? Yes. Oh. Thank you, DCJ. Good afternoon, Mr. Swanepoel.
Good afternoon, Commissioner.
Can I just following on that line of questioning, I just want clarity on the timeline of your career. You joined the bar in 1989. That's what you just said.
Yes, I signed the Red Book, I believe, in July or August 1989.
And then you say in 1.7 thereafter you were headhunted by a firm.
There was a large firm of attorneys on the East Rand that was doing a lot of litigation, and they made me an extremely good offer, which I felt at that stage, being a young counsel, with a new career that I couldn't turn down. So I went there, and I continued to do litigation on a daily basis.
But in what capacity did you join the firm?
I was an article clerk eventually, but in the beginning, and then, but effectively I worked as if I were a partner.
Just take 2 steps back. You said you were an article clerk.
Yes.
Does this mean you now were placed on the role of attorneys?
Yes, I was. Well, I joined the firm. I signed a contract of articles, and in 1993, I think, I was admitted as an attorney.
Sorry, 19?
93, I think. I served 2 years articles, yes.
Yes. So I just need to get this clear, and this is where my confusion stems from. You were first an attorney, and then you joined the Joburg Bar in what you've just said now was 1989.
No, I was a prosecutor until 1988. I realized that I wanted to go to the private sector. I then joined the bar. I wrote my bar exam in July of 1989. A year or so later, I was made this offer by this firm of attorneys. I did my 2 years articles there, and I became an attorney in about April 1993, if I'm not mistaken. And I then worked as an attorney for the following 10 or 11 years.
So you were, at the time when you were Attorney General, were you not in the role of attorneys?
No. The Attorney General's office is the Director of Public Prosecution's equivalent now.
All right. I just want to be clear. So you were first on the role of advocates.
Before I became an attorney, yes.
Yeah. Can you just take it slow? You were first on the role of advocates.
Yes.
You removed yourself from the role. When was that? What year?
That was in 1991, I believe.
All right. And then you placed yourself on the role of attorneys.
Yes.
In 1993.
Yes.
And then you say you appeared in criminal and civil appeals, etc. And in 1.9, you says, as counsel from 2004 onwards, I was briefed by attorneys.
Yes. Yes, that is correct.
So what happened after you were placed on the role of attorneys?
I became a director in a firm we were 3 or 4 directors in 1994. And I worked in that firm until 2004. In 2004, I realized that even though I was doing litigation to a large extent, I really needed to go back to the bar. I wanted to focus solely on litigation. And even though I was doing litigation as an attorney, there are other duties that you have to do as an attorney which are administrative nature and so on, which I didn't really enjoy. So I went back to the bar in 2004. I had myself removed from the role of attorneys and put back onto the role of advocates, and I'm still there.
All right. Now, can I just ask you to go to page 19? Now, this is the certificate of good standing from the LPC.
Yes.
And you'll know how these certificate of good standings these certificates of good standing are obtained. You provide the LPC with your various court orders, and they provide you with a certificate of good standing.
Yes.
Now, the certificate says that you were admitted and enrolled as an attorney in 1993.
Yes.
And then it says that your name was removed from the role at your own request in 2005.
Yes, that's right. I'm sorry, it wasn't 2004, it was 2005. Correct.
Yeah, but my confusion stems from the fact that you've just said to us that you were a member of the Johannesburg Bar before that.
Yes, I was. Between 1989 and 1991, I was a member of the Johannesburg Bar. I then became an attorney. I became a member of the Law Society, as it was at that stage, when I qualified to be an attorney in 1993. I remained an attorney until 2005. I then went back to the bar. I removed my name from the role of attorneys and enrolled myself as an advocate.
So you just neglected to tell the Law Society of your previous stint as an advocate?
No, No, not at all. The Law
Sorry,
Society,
the
the Law
LPC.
Society just deals with these periods that are relevant to them.
No. The LPC, when it issues you with a certificate of good standing, has to record all the points in your career where you were admitted on the roll and removed from the roll of the various professions. That's
Yes.
the role of the LPC,
Yes.
to pull all of that information together. What I just picked up is that your certificate of good standing doesn't reflect your earlier time at the bar.
I'm sorry, Commissioner, I didn't realize that it was supposed to. I thought that it only had to deal with this period when I was an attorney and then became an advocate. I didn't realize it had to reflect what happened before. If I had known that, I would have had it rectified. I simply asked for a certificate of good standing, and this is what I got. And this is correct. It might be incomplete, but I'm sorry about that. But that was not my understanding that it needed to reflect the earlier period as well. But I take that on board, Commissioner.
Thank you. Thank you, DCJ.
DCJ, sorry, you're inaudible.
DCJ, your mic. Your mic is off.
Thank you. Do you have any questions for the candidate, Commissioner Singh?
Yes, thank you very much. I couldn't hear
You may put them.
Okay. No, thank you very much. Good afternoon, good evening, Advocate Swanepoel.
Good evening, Commissioner.
I'm very interested in your response on the Section 37C, where you said legislation needs to be more particular and it's quite arbitrary. And I'll tell you where I'm coming from. Some of the commissioners seated there and I sit as trustees on the Parliamentary Office Bearers Pension Fund. And 37C has always become a problem for us in explaining it to our members of Parliament. Because in most instances, they argue that if they fill a beneficiary form, then the trustee should honor what they've indicated on the beneficiary form. But when we sit as trustees, we've been told that in terms of the Act, you've got to look at all of those who benefited financially when the particular pensioner was alive. Now, when you suggest amendments, what are you saying in terms of what we are faced with? And how do we resolve this kind of situation that we find ourselves? Because we are called all sorts of names as trustees because we do not honor the wishes of the pensioners who are alive when they fill those forms.
Yes. Commissioner, thank you. Commissioner, I haven't really given any thought to what it should look like, but what I can tell you is what is happening at the moment. And as you say, I'm sure you get a lot of complaints, is that in this particular case of Swat versus Lukamane, the deceased had nominated his children to receive the pension benefit. And the pension then decided, well, they weren't going to do that. They were going to give everything to his wife. Now, they did that based on incorrect facts altogether, and that's why the matter was reviewed. But it seems to me that any pension fund can decide really in any manner that it wishes to allocate funds. There isn't a set standard by which the fund must consider the different claims from the different parties. So it might be useful to say, well, what weight must one put on a nomination form? Can it just simply be ignored? What weight should one put on the different family relationships? Is a wife entitled more because she is the wife? So those are questions which I think are quite vexing, which would have to be thought about. But at the moment, it is a problem. And it has been in other matters that I've also dealt with in private practice. I'm not sure that I've helped. Sorry, I'm not sure that I've helped you, Commissioner.
No, I think you've helped Advocate Swanepoel because we are looking for ways to re-look at 37C and try and make sure that those members who bring their complaints to us are catered for in one way or the other.
Yes.
And their argument to us as trustees and members of parliament as well, we make the law, let's change the law, but it's not only a law for members of parliament, but it's a law for everybody who receives a pension. But I'm sure we'll be contacting you and the good Professor Commissioner to talk about this 37C further.
Thank you, Commissioner.
Thank you, Commissioner Singh. Commissioner Nyambi?
Thanks, DCJ. I was covered by DCJ about what happened the last time we were here. But to be fair to you, because we'll be having the deliberations, Commissioner Ngugaitobi asked you about your shaky understanding of the core business of what is happening at that division you want to go. And you said you are going to learn there. Did I understand you well?
Sorry, no, Commissioner, I'm sorry, I didn't hear the question.
When Commissioner Ngugaitobi gave you an opportunity to comment about your understanding of
Yes.
your administrative law,
Yes.
and then you said, we are ready to go and learn. Did I understand you well?
No, Commissioner, with respect not. Expressed myself incorrectly. I have a good understanding of the constitutional framework within which we work. When it comes to a specific subject relating to a constitutional matter, I am able and I will study myself into the subject to the extent that I can go and write a good judgment, that I make sure that I'm correct. The two constitutional judgments that I've written both haven't been attacked. The one was taken on appeal and the appeal was dismissed. So I'm able to gain an understanding of the subject I'm writing about. And I won't write until I've got that understanding. That's my philosophy, that I can't just go into a judgment willy-nilly. I must know exactly what I'm writing about. So that's what I'm saying is, yes, I have not had administrative experience in my private practice, although I'm now busy with a constitutional matter in private practice. But I have written on it, I've been upheld on appeal, and I will make sure that I study myself into the subject properly. So it's not a question of going into a judge's job to learn.
Study properly.
To study. We always study, Commissioner, so it's an ongoing thing, yes.
Oh, thanks. Thanks, DCJ.
Can I do
Thank
a
you,
quick
Commissioner.
follow-up, please?
JP Mlambo?
Thanks, DCJ. I just need to clarify one thing about this certificate of standing, Advocate Swanepoel. Are you the one who gave the LPC this information, or it's the LPC that issued this certificate?
Yes, how it works, JP, is this. There's a lady who works at the LPC, you phone her up and you say you need a certificate of good standing, and she emails it to you. You pay the fees and she emails it to you. I have never been au fait with what the requirements are for the certificate of good standing. I assumed that it was correct, as it is now, because the information is correct in it. It might be incomplete in respect of my early days, but it is correct.
Thank you, DCJ.
Just to follow up, DCJ, I think this is important. I think and Judge President raises a very important point. My understanding is this certificate actually operates from a period to a certain period. You don't get it in eternity. In other words, you get it. You have to apply for it every financial year, because there are possibilities that you might be in good standing now, but next year not be in good standing.
Yes,
and the one I have doesn't list all the information. Just said this person was admitted on this particular period and still in good standing. So
yes, Commissioner, that's how I understand it. This is about the third or fourth certificate. No, the third certificate I've applied for in the last 3 years, and they've all looked the same. I sincerely didn't realize it was supposed to be more complete than that.
Commissioner Steinberg, first. There are 23 commissioners, and I have to make sure that everyone has a fair chance to ask questions. You will now get your opportunity to ask your follow-up question. The candidate is still here. He's not going anywhere until we've questioned him as much as we want. Ma'am?
It's just to finish the previous line of questions. I think we all accept that nobody ever knows everything. The concern we're expressing is that you've showed a lack of knowledge and understanding of one of perhaps the first principle of constitutional and administrative law when it comes to remedy. And that's that you can set aside conduct, but not, you can declare conduct unlawful, but not set it aside. And the fact that you can't differentiate between the two is very disturbing, because that is truly the ABC of remedy in administrative and constitutional law. So it's not that one would expect you to know everything, but that is really the basics, and particularly acting in the Gauteng courts, a judge just has to have the basics of administrative law.
Commissioner, thank you. I hear exactly what you're saying to me. But can I just repeat this? I've written extensively on Paja. If I say extensively, I've probably written 5 or 6 or 7 judgments on Paja and reviews. As I say, I've written those 2 judgments on the constitutional issues. And in all of those cases, I've never been overturned. And it's because in that particular case, I've made sure that I understand the subject matter. I've never been asked to set a tender aside. So I've never read on that particular issue. It's not something that's come before me, but I can assure you that if it had come before me, I would have mastered it. I can only point you to the comments of the GCB on my judgments. They say specifically, I can maybe read it to you. They say specifically that my judgments are sound and well written. I'm meticulous in setting out the law, the applicable facts, and then dealing with the vexing issues in casu. So I make a particular effort before I reach a decision to understand that particular field of the law completely. So with respect, that is why I believe that I have been able to write really good judgments, for instance, in medical legal matters, for instance, in the matter that has already been referred to. No, I don't hold myself out as being a constitutional scholar. I hope to be at some stage. I hope to have your breadth of knowledge of the Constitution, and I'll get there. That's really as far as I can take it, Commissioner.
Thank you, DCJ.
Follow-up, DCJ?
Yes, Commissioner Bernard.
Advocate Swanepoel, have you ever been overturned on appeal, any of your judgments?
I haven't, no, Commissioner.
Thank you, DCJ.
All right. Any further questions, colleagues? Advocate Swanepoel, we've reached the end of your interview. Thank you so much for making yourself available.
Thank you, Deputy Chief Justice.
I don't know if there's anything else you want to say to the Commission before?
No, thank you. It's been an interesting time. Thank you, Commissioners.
All right. Thank you, sir.